The issue is why is there congestion? We have said most of those in prison are not meant to be there. We have stringent bail conditions. We are not talking of sentencing now. We are talking of being in prison and overcrowding of the prisons. Now, what I'm saying is that now we are saying sentencing, for instance. People are giving bail applications, for instance. People are giving stringent bail conditions. Somebody is told to go and somebody who just stole something, maybe a fowl or something, is asked to drink a surety, a level 16 officer in the state government. You understand? How can that get that? So, and sometimes also in sentencing. Now, there are people who are meant to be giving community service and some other, non-custodial sentencing. You find them, because now if you talk about the fact that the laws do not allow for this, the ACJL has been passed since 2007. And we have a review of the ACJL in 2011. When you look at section 264 of the ACJL, it gives for remand proceeding. It says once a prisoner who has committed a capital offense, for instance, is brought to court, the magistrate who do not have the power to try such a prisoner should remand him, subject to a review in 30 days. In 30 days, the court should show more to release the prisoner. And the court can also issue hearing notice to the Commissioner of Police the Attorney General of the state to state why, to show cause why the inmates should not be released. And 1 month after, the inmates should be released. But now, I can tell you that most of the magistrates I have appeared before many of them, and most times they are very reluctant to effect the provision of this law.
Yes. The problem is that you cannot effect the provision or give effect to the provision of the Administration of Criminal Justice Laws of Lagos State 2011 without having recourse to the DPP report. The question again goes that, please pause, when you have sent a report, particularly in cases that are very stringent in nature, like robbery, murder.
What of all the reports? I'm talking of when the report is not forthcoming.
This to the DPP. The DPP is supposed to come up
when the report
a legal advice.
When the legal advice is not forthcoming, what should the DPP do? What should
the question is, why will it not come?
It does not come.
Why is the delay? Why is the delay? That is why I hold the state responsible. Because if the state has the vein of transmitting the blood of innocent persons, the state would have been diligent in ensuring that there is proper communication between the office of the DPP and the respective police station vis-a-vis the magistrate courts.
Okay, 1 second. Someone's asking a question and I think I should bring it in because he wants clarification. You're saying it's the judiciary. You're saying it's the state. His question, and I think the both of you can weigh in on this, is the judiciary not part of the state?
Yes, I submit that we have 3 arms of government, and that is the executive, the legislatures, and the judiciary. The whole essence of the judiciary is to interpret the law and, where the need be, apportion blames. Now, the police fall within the ambit of the executives because they enforce these laws that are made by the legislatures. So when you talk about failure in the state as it concerns implementation of these laws, you are talking about the state. You are not talking about the judiciary. Okay, so but his argument is that the judiciary, in interpretation of his, or in exercise of his judicial power, contributes to the delay.
Yes, in fact, most times they overindulge the prosecution.
So that is the position. But I refuse.
I've been to a magistrate court. The person in question has been in prison for over a year, and the question is, Your Honor, please apply the provision of Section 4 of the ACJL. And what I was told, she adjourned for over a month. And anytime, some other cases are equally adjourned, and you just hear the prosecution will just stand up, the police prosecutor at the magistrate court will stand up and say, so case awaiting DP advice.
Remedies for this misnomer.
It is found out
these
that
anomalies can be ameliorated.
The police do not even send the duplicate file. So what should the magistrate do? The magistrate has the power to strike out the case, but they won't do that. That is my contention here.
So the magistrate is constrained, waiting for the police.
Yes.
But the question is that
against the provision of the law.
Who is the police? Who is he working for? But the point here that I want to...
No, hold on. Yes. Go back again.
I say, who is the police? Who is the police working for? He's working for the state. He's not working for the judiciary. even if he's prosecuting on behalf of the state.
So he's not bothered that he's holding up the judiciary. He's not bothered that he's holding up.
That is that lack of conscience. That lack of conscience in states. The feeling I said that the blood of wickedness is the only thing that runs in the vein of the state.
But he also said why is it that the magistrate who has the powers to strike out the case continues to wait for the police when he can just...
Yes, you see, I can give you a ready-made, sorry, I can give you a ready-made answer. The ready-made answer is that there are these suspicions from some of these magistrates that the prosecutor, who is a policeman, whose black has hidden the white of the heart, if he has a white heart, now may have colluded with even the accused person.
That is why
there is suppression of justice.
That is why the law provides for invitation of the commissioner of police and the AG or their representative. But that is not done. Another issue is the issue of emotions.
That is not done. Who is supposed to do that?
The judiciary is meant to do that. The law provides that the judiciary should issue hearing notice to the commissioner and the commissioner for justice and commissioner for police to show cause why the prisoner should not be released. And I've never seen any of them do that.
I do not agree with you.
Why do you think they don't do it? Sometimes
is maybe a lack of emotions or feelings for the downtrodden. Because some of them, there's the case of a judge in a western state, I don't want to mention the state. The judge sentences prisoners to life imprisonment, death sentence at will, because the judge was at the point in time robbed. That is the suspicion. So many of us have this feeling. Once we have been victims, or because of the societal, the societal menace of some of these people, I forget that an inmate or an accused person is innocent until proven guilty. But otherwise is the case. They require them to prove their innocence most times, not the state proving their guilt. And that is my...
I do not agree with you, save and except the word you are guilty is pronounced. You cannot say that the person is not presumed to be innocent. But the onus is on him to get a proper representation where there is what looks like legal aid for what looks like a window dressing, but they are not effective. And this is the childbirth of the state, saying that they want to assist the downtrodden. They want to assist those who cannot afford legal representations. And most often than not, you see that these legal aids is only a paperwork. In recent, you don't see them in court. And even while they are in court, they are not active.
It's not so.
And then you see that some of them just come to take dates at will.
It is not true.
You hardly see cases where they have prosecuted up to court of appeal. And if you can cite cases where the state, in exercise of its legal duties, have provided somebody with an aid up to court of appeal.
The OPD, enough cases. The OPD are doing a lot in Lagos State. And Lagos State government has also created a platform for private practitioners to assist the state. For instance, the LPIP, which I'm a board member of. I will have at least personally, I have done more than 20 cases relating to inmates. One of the cases, I represented about 131 inmates, and 94 of them were released from the prisons. They've been there between 4 and 12 years.
On whose order were they released?
They were released on the orders of the court.
On the orders of the court.
Yes.
And you said the judiciary are not performing their duty. Could the judiciary have released them so much too? Without the court
on the orders of the court, and the same court equally reminded them there.
But
did you hear what he said? Yes. Could the court have released them if there was no
application, no legal representation?
No, in the first place, we are talking of legal representation after the damage has been done.
The question, could the court have released them if there was no legal representation?
Yes. The court, based on the provision of 264, which I said, some of these inmates were released, were imprisoned just as late as 2008, 2009, after the ACGL has been enforced. So the court can suo motu on its own release them. That is the provisions of the law. And now that provision has been reinstated in from section 293 to about 297 of the new ACJ, which has just been passed in May. So in Lagos, for instance, we have no excuse.
I do not agree with you that the court can suo motu. In absence of files, remember that when a case is called in court, if you have a legal representation, you will announce his name. And there are some cases where I have been to court to defend an inmate, and I'll discover that his name or her name is conspicuously missing in the court list. On the strength of that, I will draw the attention of the registrar of the court. Please let me finish. And then they will list it or give me a date. Now the question is this. If such person has no legal representation, the continuation of the record would have been swept under the carpet. And the person will now continue to languish in prison without the prison officials
my contention is
raising an issue.
My contention is that the law gives the judge power to review these cases.